President, and judges of the Caribbean Court of Justice. Please be seated.
The Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados. Hearing of application in the matter BBA CR 2023-001 between Alex Tasker and the United States of America. The members of the hearing panel are the Honorable Mr. Justice Saunders, President and Presiding Judge, the Honorable Mr. Justice Anderson, the Honorable Madam Justice Rajnath Lee, the Honorable Mr. Justice Barrow, and the Honorable Mr. Justice Burgess. Counsel, you may now enter your appearances.
Good morning, Your Honors. Should it please the Court, Mr. Douglas Mendez and Mr. Andrew Pilgrim. Lead me, Clay Hackett, on behalf of the applicant.
Yes, good morning.
Good morning, Your Honors. If it pleases this honorable court, Alliston Seal, and with me is Mr. Oliver Thomas, Principal State Counsel, and we appear for the respondent, the government of the United States of America.
Yes, good morning, Mr. Steele. Yes, Mr. Mendez, are you ready?
Good morning, Your Honors. Your Honors, there is no dispute between the parties that this honorable court has jurisdiction to reopen the application for leave which was refused in this judgment. Neither is there any dispute between the parties that the court will exercise that jurisdiction in exceptional circumstances where it can be established that there has been a miscarriage of justice. So that unless Your Honors wish to be assisted any further on those 2 points, that is, as far as the agreement between the parties goes.
Yes.
There, however, is no agreement that the court can exercise its jurisdiction where there has been a breach of the principle of natural justice, that is to say, the right to be heard. I say that there is no concession because my learned friend has not in his written submissions in any event sought to say why that would not be a basis for the court reopening a matter that has already been determined. And he doesn't say why he thinks that the decision of the Privy Council in the Sans Souci case is wrong. That case, of course, unless Your Honors wish me to go to it, establishes very clearly that one of the bases upon which the court will consider that there are exceptional circumstances involving a miscarriage of justice is where apparently is an audio problem.
If you could speak into the mic, Mr. Mendez, it would help us.
Is this better?
Try it again.
Is this better?
Yes, I think so.
Marginally.
Yes, marginally.
Marginally.
Marginally. Any better?
I think so.
I'll try to speak loudly as well, Your Honors. Yes, I was just pointing out that the Privy Council in the Sans Souci case had established that that any decision of a court is premised upon the rules of natural justice having been complied with. Or I should say the principle of finality is premised upon the rules of justice having been accorded to the parties in the proceedings. And therefore, it is accepted that one of the grounds upon which a matter can be reopened is if those principles of natural justice have not been complied with. The authorities that have been cited, the ex parte Pinochet case, the Taylor and Lawrence case, for example, accept that one aspect of the principles of natural justice, that is to say the appearance of bias, would have found a basis for course, it could be established that the principle against bias has been infringed. We respectfully submit that similarly, if it can be established that the decision was made in breach of the right to be heard, then that would constitute a miscarriage of justice. That would also be a basis upon which the court would be justified in exercising the jurisdiction to reopen an application. And that is as much as I have to say on that particular point. Of course, the next question is whether there has in fact been a breach of the principle of natural justice in this particular case. And again, in that regard, there is no agreement between my learned friend and us. There's nothing further on those 2 points. I'll proceed to that point.
Mr. Mendez, I am hearing you perfectly clearly. I'm just concerned about those who are recording, whether the clarity is also attendant. Is that from those who are recording? Mr. Mendez is being heard clearly?
Yes, sir.
Yes? Okay, yeah, thank you. I'm so sorry.
Your Honors, the question whether there is a right to be heard and whether that right to be heard was infringed on the application for leave to appeal has to be taken in the context of the proceedings that preceded the application for leave. This is an extradition case, and at the heart of it are certain constitutional rights that are important. There is the constitutional right that is provided for in section 1 second, please. In section 18 of the Constitution, in particular, section 18(1), which provides seems as though I have extracted the wrong provision. That is a provision dealing with the protection of the law. What I am referring to is the provision in the Constitution that protects freedom of movement, which is section 22 of the Constitution, I apologize, which provides that no person shall be deprived of his freedom of movement, that is to say, the right to move freely throughout Barbados, the right to reside in any part of Barbados, the right to enter Barbados, and the right to leave Barbados, and immunity from expulsion from Barbados. That right is made subject in subsection 3 to laws which provide for extradition. That is an express exception that is provided for.
Just to be clear, I'm following you, please. You are arguing that the rules of natural justice were not complied with on the hearing of your application for special leave before the Caribbean Court of Justice. Is that what you're arguing? I see. How would you then reconcile that position with the clear rules in the rules of court of the CCJ, which gave you the opportunity to present all those facts which are necessary for the CCJ to determine the application for special leave?
Mr. Mills, before you respond, apparently there's a lectern, so that maybe you should go to the lectern, as I understand it. There is,
Here?
the registrar will point it out.
And that has the advantage that we can see you more clearly as well.
Well, I am now divorced from my assistants, but in any event, I'll do the best that I can. If I have to run across there, I'm sure you wouldn't mind too much. Yes, Your Honor.
I thought the comfort of Mr. Pilgrim's presence was in fact being denied you by being advanced. But go ahead.
Yes, Your Honor, I appreciate that that is a question that ultimately has to be answered, and I will come to it. I'm setting the stage, as it were, by saying that at the heart of any case like this that comes before the CCJ on an application for leave to appeal is the right to remain in Barbados, which is subject to extradition law. And therefore, what is involved in a trial before a magistrate as to whether the stipulations in the Extradition Act have been met, which would justify somebody being extradited, as well as all of the other provisions for appeal and so on, is a determination of the circumstances in which the right to remain in Barbados can be foregone. So I'm putting it in that context. There is a contest in the magistrate's court, there's a contest in the Court of Appeal, and there's a contest in the CCJ over the question whether there is justification for, as it were, departing from the right to remain in Barbados. So that is the context in which I'm seeing this. I'm saying that in this particular instance, of course, there was an attempt to exercise the right of appeal against the magistrate's decision to the Court of Appeal, which failed because it was found that the application for leave was brought out of time, and the Court of Appeal held that it didn't have the jurisdiction to extend time. And therefore, the applicant sought access to the CCJ in order to be able to advocate his objections to the findings made by the magistrate. The point being that this is the last occasion or the last avenue that the applicant has to put that case before the courts, in order that he can say, for example, that what he is being extradited for is not an extraditable offense, and therefore he cannot be extradited in accordance with law. To say, for example, ultimately, if he's granted leave, that the evidence that was brought before the court did not meet the standards under the Extradition Act, to say that in the application of the law, the reciprocity rule was applied properly, and so on. All of these points that are important in extradition law in order to determine whether your right to remain in Barbados can be set aside for the time being.
Sorry, Mr. Mendez. You make reference to a right to appeal. Is there really such a right in Barbados? I agree with you that the Constitution gives a right, a protected right under Section 23, I think it is. But is there a right to appeal?
No, it isn't. It's an avenue of appeal. Of course, if you are able to satisfy the rules for leave to appeal, then this is the avenue by which you challenge the decision of the magistrate.
So it's more accurate than to...
An avenue.
Okay.
And likewise, there's an avenue of appeal to the CCJ by way of the application for leave to appeal. But the point that I'm making is that that is the last opportunity in this particular case that this applicant had to be able to go before the courts of Barbados in order to establish that the extradition law is not being complied with, and therefore his right to remain in Barbados is being infringed, or he's being sent from Barbados not in accordance with law. So I'm saying that even if it wasn't his last opportunity, the fact is that what this court is called upon to do in determining whether leave to appeal shall be granted is to exercise a judicial function. And the presumption is that he has a right to be heard. The question is whether the rules make provision for that, and I'll come to that in a moment.
Mr. Mendez, when you come to the question of what he had to satisfy the Court of Appeal to get leave to appeal,
Yes.
you would just address that, because in answer to my brother Burgess, you said that if you satisfy the rules,
Yes.
yeah, for leave to appeal, the Court of Appeal may grant leave.
Yes.
So when you get to that stage, I know you'll get to it at some stage,
Well,
you will let us know what those rules are.
Your Honor, you are saying in relation to the
Application for leave to the Court of Appeal.
Well, certainly you have to establish at the very least that you have an arguable case. So you have to put before the Court of Appeal sufficient material for them to say, okay, this is something that we need to have a full appeal to hear. So at least an arguable case you have to establish. So that what the court is engaged in is an assessment, even at that early stage, of what the magistrate has done, whether the magistrate determined properly that there was an extradition crime. As a matter of fact, one of the complaints is that when you read the magistrate's reasons, he doesn't even reason, he doesn't even cite Barbadian law to determine whether an offense against Barbadian law has been committed. So those are the type of things he would wish to put before the Court of Appeal so that the court can consider whether the Extradition Act has been complied with.
Just for my sake, Mr. Mendez, did you get that to that stage of the Court of Appeal, or were you shut
we
out
did
just
not.
on time?
No, we did not, because the objection was taken that the application for leave to appeal was made out of time and that the Court of Appeal didn't have any jurisdiction to extend time. And so that was the end of it. There was no determination made. I'm not even sure there were any arguments on the merits, but certainly there was no arguments on the merits. But the matter ended there.
Mr. Mendez, wasn't this because the Court of Appeal didn't have jurisdiction? The only way it could have jurisdiction is pursuant to the Extradition Act.
Yeah.
And if it was approached through any other avenue, would it have jurisdiction to hear the matter?
Well,
I know that if you got the matter before the Court of Appeal, then the inherent jurisdiction in the Court of Appeal would allow an amendment to the notice which you would have submitted. But in the absence of compliance with the Extradition Act, what would give the Court of Appeal jurisdiction? I've been struggling with that.
Well, Your Honors, if the court didn't have jurisdiction, obviously, it must first determine that. And it would not ordinarily say, I'm going to consider the merits, because I don't have jurisdiction to consider the merits. The court made a finding that it had no jurisdiction to extend time at all. We respectfully submit, and this is what we wish to say to this court, that it was wrong in finding that it had no jurisdiction, because this court said that there would be jurisdiction in exceptional circumstances to extend time. So the court didn't even consider the question of extending time because it said it had no jurisdiction. That's contrary to the Dean and Allenby case, for example.
But in Dean and Allenby, jurisdiction was established. The court didn't think it, this is the Court of Appeal, didn't think it had the power to extend time. But here we are, I suspect, in a different ballpark, because we're in a situation where, as it seems to me, where the Extradition Act appeals in respect of extraditions must proceed under the Extradition Act. And the Court of Appeal, in searching for its jurisdiction, would have to find jurisdiction in respect of extraditions in the Extradition Act. Am I right in believing that?
Absolutely, Your Honors. But what this court held in Dean and Allenby, and which is followed by the Bahamian Court of Appeal in the case that we have cited of Culmer, is that the court in fact has jurisdiction to extend time. Whether it will extend time in a particular case is another question, and these principles of law that would apply to the extension of time are being worked out from case to case. But the point is that what the Court of Appeal said is that they didn't have jurisdiction to extend time at all, so they gave no consideration to the question whether time should be extended. So that is part of the reason why we are here. We are saying that there is jurisdiction to extend time, and if you don't, that is our fallback position, because there are other submissions that we wish to make as to how the notice of appeal that was in fact filed, albeit under the wrong act, ought to be treated and so on. But I'm getting to that. I'm attempting to establish in the first place that there was a right to be heard before this court on the application for leave to appeal, and that right was not accorded. And this is where I'm coming to by first of all establishing the importance of the application that was made to the Court of Appeal, to the CCJ for leave to appeal. What wrote on it, the point is that having determined that having refused leave to appeal, that is the end of it. The applicant cannot make the points which he wishes to make, that his extradition is not in accordance with the Extradition Act. So that the point is a lot turns on the question whether the applicant was afforded due process, was afforded the right to be heard before the court.
Yes,
Now,
and I think
before I
that's...
come to the rules, and I will come to
Yes,
them.
yes.
Before I come to the rules,
Yes.
I just want to refer you to what the Australian court had to say. This is the Australian High Court had to say about the applications for leave to appeal. And this was in the decision of Smith-Kline against French. Can I put this underneath here? Yes? I'm sorry for the highlighting, Your Honors. I didn't expect to be putting my papers before you. But you'll see the highlighted part says that notwithstanding these special features, that is, the special features of the application for leave to appeal, an application for special leave to appeal, like an application for leave to appeal, is an accepted and long-standing curial procedure in this country. The procedure calls for a hearing, whether orally or on written materials, and a determination in the form of a curial order. If the application be refused, the order dismissing the application is the final curial act which brings the litigation between the parties to an end. An application for special leave to appeal, therefore, involves the exercise of judicial power. We respectfully submit, and I'm asking the court to approach this question from the standpoint that there is a presumption of a right to be heard. There's a presumption of a right to present arguments before the court as to exactly why it is that the applicant is saying that the Court of Appeal went wrong and therefore that the special leave to appeal ought to be given. The question is whether, as my learned friends say, that right is accorded in the rules, and if we didn't put our full case before it, well, then that's just too bad. We are out of court. And I would respectfully submit that the rules, properly interpreted, do not provide for an opportunity to be heard, and the expectation is that at some point in time, directions will be given for such a hearing.
Mr. Mendes, before you move on, the matter of the jurisdiction to extend time.
Yes.
That is critical to your application, is that right?
Yes, one of the limbs of the application.
Right.
And it is, yes, it's important.
What has engaged me is the provision in the Extradition Act, which seems contrary to what existed, let's say, in Dean and Allenby and other cases, a provision which seems to suggest that this is an absolute requirement, and the court may not give leave unless the 15-day time limit is complied with. I think that's section 20, sub 2A.
Yes.
Is that correct?
It does say that. It says that the court may not grant leave unless you have brought it within 15 days, but I don't understand the authorities to turn on the interpretation of the provision. All of the authorities accept that the court has no jurisdiction to hear the appeal if it is not brought within time.
Right.
And then if the question that arises, well, do you have the jurisdiction to extend time?
Well, sorry, but this is exactly what I'm raising.
Yes.
Given that language, does that not preclude the extension of time which may be available in a situation where there is a right of appeal and there is a time limit, but there is not a negative? So like an appeal shall be brought within 21 days.
Yes.
You don't bring it within 21 days, you can apply for an extension of time, even if the statute does not provide for that. But in a situation like this, and I confess that it really is deeply engaging, in a situation like this where it seems to say, the court shall not, unless, then where does that, is that any different?
I don't understand the authorities to turn on that, and I'll tell you why. It does make a difference in what language the facility of seeking leave to appeal is expressed. Because what the court is concerned with is whether the provision accords with the right to a fair trial under the Constitution. And what it is saying is that in order to ensure compliance with the right to a fair trial, there's this residual jurisdiction to extend time in exceptional circumstances in order to give effect to the right to a fair trial. In other words, what it is saying essentially is that a blanket, hard and fast, absolute rule that you cannot appeal unless you bring your application within a period of time might infringe the right to a fair trial. As one of the circumstances, as this court has mentioned, if there's a hurricane and you can't bring your papers before the court, then if you look at the rule which says it may not grant leave unless you bring it within 15 days, that certainly will not accord with the right of access to court. And in those circumstances, the court is accepting a jurisdiction to extend time. So what I'm saying is that the reasoning of the court, of this court, as well as of the other cases that I've referred this court to, is that the jurisdiction to extend time derives from the Constitution itself, because otherwise the blanket absolute provision might infringe the right to a fair trial. And of course, in this instance too, because we're dealing with also the right to remain in Barbados, and which can only be taken away in accordance with extradition law. When you bring all of those rights together, the court is asking the question, is it a proportionate position to take that once that guillotine falls and that 15-day period is at an end, there is no circumstance under which the court will give you an opportunity.
Implicitly, Mr. Mendes, listening to you,
Yes,
you're saying that a provision like the one in Section 20,
yes.
read literally, is in conflict with the Constitution.
The court is not saying you strike it down, but it's saying that the halfway position, in other words, the way in which you accord the right to be heard, the way in which you give effect to it is by accepting a jurisdiction to extend time, but only in exceptional circumstances.
If you don't extend time, then you are acting inconsistently with the Constitution.
In effect, that is what is being said.
Okay, I get you fully now. Continue.
Thank you very much. So again, that is one of the
And
things.
just to be clear, what section of the Constitution are you specifically referring to?
I'm referring
18
to
or?
this would be section, well, I referred you to the right to remain in Barbados, which is section 22(1). And then there's the right to a fair trial in section 18(8) of the Constitution, which is the equivalent of Article 6(1) of the European Convention, which is...
And I am sure you would also extend it to protection of law as well.
Well, of course.
Yes, all right.
But of course, this aspect of the protection of the law is specifically provided for
Okay.
under 18(8). And the authority that we rely on.
I think I get you.
This court's decision is on the basis of the protection of the law, right of access to court, and then the decision of the Supreme Court, the UK Supreme Court in Pomchowski, is based upon Article 6(1), which is the equivalent of Article 18(8) of our Constitution.
So if I could summarize your submission so far, you're saying that the 15-day time limit is not a guillotine.
Yes.
That if there are exceptional circumstances,
Yes.
that a court always has a discretion to extend the time.
Yes.
What are the exceptional circumstances in this particular instance?
Well, in this particular case,
Yes.
the exceptional circumstances are that the very day the decision was made, a notice of appeal was filed. And therefore, and I'll try to develop this point later on, but in other words, the applicant said, I want access to the Court of Appeal. What was not done was to follow the rules as required, which is you make an application for leave to appeal. So instead of making the application for leave to appeal on the 8th of September, he filed a notice of appeal. So he was seeking to invoke the jurisdiction of the Court of Appeal. He did it the wrong way. And we are saying that those are exceptional circumstances.
Mr. Mendes, so would it be accurate to say that he evinced an intention to appeal?
He evinced an
Slightly
intention,
different
yes,
from-
to challenge the decision of the magistrate.
Yeah, he said that I will institute an appeal.
He was knocking on the doors of the Court of Appeal to seek to say to the court that I'm not being extradited in accordance with the Extradition Act. He was seeking that. He did it the wrong way. He went to the wrong portal, but he was trying to get into the Hall of Justice. That's basically what is happening. We're saying that this...
So did it not remain in residence in his intention?
Sorry, didn't it?
Not reside, continue to reside within his intention?
Yes. But of course, he was depending upon the advice of his lawyers as to how you do this thing. So he, sitting wherever he was sitting, is saying, I want to appeal, and he's given instructions to appeal, but he is now dependent upon his lawyers to follow the correct procedure to launch that appeal. And what happened in this instance is that the lawyers didn't realize until late that you are to make an application for leave. It was made a few days after the time period.
What is
That was the problem.
What is exceptional then would be the errors of his lawyers.
What would be exceptional is that he sought to invoke the jurisdiction of the court in time and through no fault of his own. The actual procedure to invoke the jurisdiction of the court was not followed until too late. And the authorities indicate that the surrogacy principle, as it's called, that is to say that the fault of the lawyer is to be attributed to the client, doesn't apply in these circumstances, particularly where you are being deprived of your right to remain in Barbados and you are saying to the court, this is not in accordance with extradition law, and I want an opportunity to show why it's not in accordance with extradition law. But that is to the end of the argument. I'm still attempting to.
Mr. Mendes, to
deal
take you, go back to where you were.
Yes.
In Dean and Allenby, I'm looking at paragraph 12 of the judgment.
Yes.
And it's premised not only on the, according to the court, and let me just read quickly, in a circumstance such as that,
Yes.
and I believe the court was talking about a hurricane
Yes.
which shut down the country.
Yes.
It says that the court would have jurisdiction to make orders to give effect to the constitutional right to a fair trial
Yes.
and facilitate access to justice for citizens at the broader level.
Correct.
So that I wondered whether you would take us there at all, this
Yes, of
overarching concept of access to
Absolutely.
justice, and it's important.
That's the intention. If I can overcome Justice Anderson's concern about whether the right to be heard was not accorded on the first application.
Yes, thank you.
So if I can just, I'm coming to all of these points in
Thank you.
baby steps, as it were, but I will come to that as well as the decision of the Bahamian Court of Appeal and the decision of the UK Supreme Court, which had predated the Dean and Allenby case, but Dean and Allenby case was decided independently of that decision. Your Honor, I'm saying that the rules of the CCJ, as they relate to applications for special leave, must be construed against the backdrop of the presumption that there is a right to be heard. This is what I'm saying. That there's a presumption that the applicant, in seeking leave to appeal to the CCJ, has a right to be heard. How that right is to be accorded is another thing. It could be orally, it could be in writing. But we are respectfully submitting that there is a right to be heard, which must be accorded. We are respectfully submitting that the rules themselves do not make it clear that this is the opportunity that you have to be heard. It presumes that something else may happen in certain circumstances, but it doesn't make it clear that your opportunity to be heard resides in the application that you're making. So if I may...
I am having some difficulty following that because of what I said earlier. The rules expressly say that when you are making your application, you should state the information which is sufficient to enable the court to determine the application that you're making. I think you're agreeing that the hearing of which you speak may be either in writing or orally. Okay, so where you have a chance to present written information sufficient to allow the court to decide, wouldn't you say that that is tantamount to having a hearing based on the papers you have submitted?
Your Honor, if the rules made it clear that the parties were to present their arguments in support of the application for leave with the application for leave, then there would be no complaint. I'm respectfully submitting that the rules do not make that clear. And indeed, the practice has not been, in my experience, the practice has always been that when you make an application for leave, and I've done quite a few, maybe not enough, but quite a few, that there is a directions hearing, and directions are then given for written submissions to be made in support of the application for leave. So that unless the rules make it clear that you are to put your written submissions along with the application, I respectfully submit that the parties would be justified in saying, well, I'm going to wait until those directions are given.
Yes, my practice, my experience,
Yes.
and that may be a little bit more extensive than yours in this court, is that there is a variation in the procedures by which determinations are made. And in some instances, the determination is made based on the information given. In other instances, there is a direction for further submissions. And in yet other instances, there is a direction for an oral hearing. And I'm not quibbling, I'm just trying to understand where you're coming from. When you look at 10.14,
Yes.
and it says to you that you must present information necessary for the court to be positioned to decide on the application. What does that mean to you?
Well, could I ask you to look at it, please, Your Honor? It says, and I think it's on the screen, it says, the application for special leave to appeal shall A, set out the grounds of appeal which it is proposed to argue. Now, first of all, to a lawyer, the grounds of appeal are expressed in a number of different ways.
Yes.
Some people, their drafting style is to simply say that the judge made an error, or the court of appeal made an error by A, B, C, D, without then presenting an argument as to why they were wrong. The argument that would then follow is that the principle of law is X, these are the authorities that say this, and they didn't act in accordance with the law as the law stands. All this says is that you set out the grounds of appeal which it is proposed to argue. That is suggesting a future occasion on which you are going to argue these grounds of appeal.
Right.
At the very least, it is not clear that you must now present your arguments in support of those grounds of appeal. B, which Your Honor is referring to, states succinctly all such facts as may be necessary in order to enable the court to determine whether special leave ought to be granted. Now, that is not your arguments or your submissions as to why the Court of Appeal is wrong. You set out the facts. If you set out the facts alone, you don't present any argument, you don't cite any authorities and so on. At least it is not clear that this is what this is saying, that you must now present all of your arguments and put all of your authorities before the court. And then it says, be signed by the applicant or the applicant's attorney at law. But of course, that doesn't take the argument further one way or the other. The other provision that provides for serving on the other side and so on. And then 5 says, where the court decides to have a hearing of the application for special leave, the registrar shall give the parties at least 14 days notice of the date and time fixed for a hearing. Now, that could suggest that the discretion lies with the court to determine whether a hearing is to be held.
Yes.
But given that there is no previous provision that makes it clear to the parties that you must present your arguments to the court, that seems one interpretation, at least, is that what that means is that having seen your arguments, we are now going to have an oral hearing. Or not. In other words, we may decide the case entirely on the basis of the written submissions, but it is presuming that the court has before it arguments. But what is missing between the rule that says these are the documents that you must file and this provision which says that the court will decide whether there's going to be a hearing, which of course is an oral hearing, is that some direction to present your written arguments.
So if the word oral was inserted in 10.155, where the court decides to have an oral hearing, would that help?
Well, it is obviously an oral hearing
Because precise, it's to fix a place for the oral hearing, yeah.
because it is saying when the court decides to have a hearing, then the parties get 14 days notice.
Right.
So it is saying that we may decide to give you an oral hearing. But what is missing in between the making of the application and the decision to...
So, sorry, but implicit in the wording is the fact that the court may decide not to have an oral hearing.
Correct.
Okay. And if the court decides not to have an oral hearing, then going back to 10.14, the court has sufficient materials before it to decide whether to grant the application.
Because it would otherwise be an unjudicial act to make a decision not to have an oral hearing when you have had no submissions at all. in writing when you don't know what the parties' positions are. You're not in a position to determine whether you're going to have an oral hearing at all. So the presumption behind that is that you know what the party's case is. We are respectfully submitting that there is a gap between the making of the application and the court's decision to have an oral hearing or not. And that gap is a express provision in the rules requiring the parties to file written submissions or a direction from the registrar for the parties to file written submissions. Because you could have the direction from the registrar, file your written submissions within whatever period of time. The court then reads the written submissions and decides whether to have an oral hearing.
Yes. So just to make sure I understand, and I think it's perhaps the last time I will try, you're saying then that as far as you are concerned, 10.14 needs to be bolstered by reference to the fact that the applicant is entitled to make written submissions, arguments in support of the application.
Yes.
Yes, okay.
There must be a rule
Yes.
or a practice which gives the applicant an opportunity to put his or her arguments in writing before the court. Then the court decides whether it's going to have an oral hearing
Or not, yeah, okay.
We compare that with, for example, the rules that pertain in the Supreme Court of Canada, the New Zealand Court, Supreme Court, Final Court of Appeal, and the Australian High Court. And similar rules apply to the UK Supreme Court. We didn't put it before you. And all of those rules provide expressly for written submission.
At the minimum.
Written submissions to accompany the application. And then a decision might be made to have an oral hearing.
Or not.
Or not. But they expressly require the parties to file their written submissions. They limit the page numbers that you can use. They limit the number of words that you can use on the application. But nevertheless, they direct the party's intention to the need to put your arguments before the court.
Yes, and therefore, on the current wording of the rule, you did not feel comfortable putting forward all the arguments and the submissions you could have in support of your application.
On our rules.
Yes.
One could have voluntarily, but there's no requirement in the rules that you do so. So we're respectfully submitting that in the absence of a specific rule telling the parties you must file with your applications your written submissions, that the court must give directions to do so in order to comport with the right to be heard.
And ex abundante cautela,
Precisely.
you decided not to follow that rule.
Yes, and Your Honor, as happened in this case, I think if you look at the application that was made, did it set out the grounds of appeal? It did. Did it set out the facts? It did. Was it signed by the applicant's attorney? It was. It didn't set out the written submissions. It didn't set out the arguments that we have now had the opportunity to present in detail. We didn't set out any of that. Can it be said that the application does not comply with the rules because it did not have the submissions which we have now put before the court? We respectfully submit no, because there is no express requirement that those arguments be presented.
Mr. Mendes, I
Thank you.
take it you'll be saying another option would be under 10.14 to, at B, to say, state all such facts and arguments.
Or, for example, yes.
For an example, yes.
Your time is going, so maybe you should move on from this point.
So that on the assumption that the court is of the view that there's something more that needed to be provided in the rules in order to comply with the right to be heard, respectfully submit that there's a basis for the court to reopen the hearing of the application for leave, and I'll now address that. I've addressed some of the arguments already, but if I can just indicate where I'm going. Now, Your Honors, this is what was before, this is what the applicant had filed. It says, again, forgive the highlighting. It says it's a notice of appeal. It says divisional court, which was the phrase used apparently a long time ago to refer to the Court of Appeal. And then it says, take notice the court will be moved at an hour, etc., by Mr. Pilgrim on behalf of the appellant that the decision of the Magistrates Court on 8 September was erroneous. Now, so this is a document that is floating about in the court somewhere. Somebody is attempting to invoke the jurisdiction of the Supreme Court, but they.
This was filed within the 15 days?
Sorry?
This was filed within the 15
That
days?
was filed on the very day of the decision.
I see.
That's on the 8th of September. So there's this document there, but it is not in accordance with the rules because it wasn't an application for leave to appeal. It wasn't an application for leave to appeal. If it was, it would have been filed in time. Now, Your Honor,
The magistrate had indicated, provided some guidance about how the appellate process ought to have been prosecuted, as far as the records show. Yes.
the magistrate, the evidence is that the magistrate said you have a right to apply to the Court of Appeal within 15 days. Or, I don't know if the words leave to appeal was said, but certainly
Was there no mention of the Extradition Act by the magistrate?
the extradition act, yes.
Yes, so in other words, the magistrate was pinpointing the correct procedure to be taken to seek leave to appeal,
That's correct.
but that was ignored by the attorney, I take it.
Well, again, the applicant, and this is respectfully submit who we should be concerned with because this is the applicant's constitutional rights that are in jeopardy. The applicant is going to act on the advice of lawyers, and as far as the applicant is concerned, this is what complied with the advice given by the magistrate. As far as the applicant, because the applicant is acting on advice. So the point is that if you look at this, doesn't say that this is being filed pursuant to the Magistrates Court Act. There's nothing that says that, except possibly, it is, I should say, the form of a notice of appeal that you will find attached to the Magistrates Courts Act. But it doesn't specify that this is being filed pursuant to the Magistrates Courts Act. The only indication of that is those numbers you see up towards the top right-hand corner. Order 21, Rule 22, which apparently is the order of the appeal rules applied to Magistrates Court decisions governing appeals. So, but by this time, in any event, that order had been replaced by another order, which was actually 46. So this was an old form that was still in use that the parties utilized to invoke the jurisdiction of the court. But I'm saying that on the face of it, there's nothing that says that this is something that is brought pursuant to the Magistrates Court Act, but the parties have said that is what we were seeking to do, and this has been admitted, that we were seeking to invoke the procedure under the Magistrates Court Act.
Would I be presumptuous to say that this is nothing? It says nothing.
Well, it says notice of appeal, and it says that I intend to argue.
These are words.
The court will be moved, yes?
These are words, but does it make legal sense?
Well, it is an expression of an intention of a party to access the court to make an argument.
But the Extradition Act does not permit of intentions.
Well, Your Honor, if what you're saying is that the document is to be treated as not being in existence, I respectfully submit that there's authority to say that you don't treat it that way. You treat it as voidable rather than void. Now, we have referred you to the authorities that say that. And what I'm saying is that given that accepting that as we accept, the intention of the lawyers was to file this notice of appeal under the Magistrates Court Act, we rely on section 18.8 of the Interpretation Act that says, notwithstanding that a statutory instrument or statutory document is expressed or purports to be made or issued by a person or authority under a specific enactment, in other words, assuming that this is expressed to be made under the Magistrates Court Act, notwithstanding that, it shall be deemed also to be made or issued under all powers thereunto enabling that person or authority. So we say that this at least ought to be treated as though it were a notice of appeal filed under the Extradition Act. And you will immediately say, but you can't do it.
Which is not possible.
You can't do it until you get leave.
Precisely.
And this is why we refer you to the decision of the Trinidad and Tobago Court of Appeal in Lala against Batiste, in which the court had to consider this very situation where a notice of appeal is filed without having had leave. And the court says this, in my judgment, You see it there on the screen, Your Honor. In my judgment, when
Whose judgment? Sorry, you knew the.
it's on the screen.
No, I know, but the.
I'm reading from here, Your Honor.
Yeah, no, I just thought that you had the judge's name.
This is Justice Nelson.
Okay, thanks.
I see there, Your Honor. In my judgment, where the court of, and this is a unanimous judgment of Justice Nelson, Justices Satnarayan Sharma and Ibrahim. In my judgment, where the Court of Appeal has jurisdiction to grant leave to appeal, a notice of appeal filed without leave is not void but voidable. Accordingly, it would be open to the appellant to seek leave after filing or for the Court of Appeal in its inherent jurisdiction to grant such leave. In this new millennium, judges ought not to allow arid technicalities to stand in the way of the litigant having his or her grievance heard and determined. I therefore hold that even if leave to appeal was necessary, I would grant such leave and treat the notice of appeal as effective from the date of filing. Accordingly, both preliminary objections are overruled. Now, this is an example, and this example of the courts not adhering to arid technicalities, that is an example, and this is replicated in the jurisprudence of this
Just
court.
for my sake, Mr. Mendes.
Yes, sir.
In that case, was the notice of appeal which was it filed under the same act which called for leave?
Yes.
There weren't two acts involved. It was one act which was involved.
Yes.
Thank you.
But what I'm saying, Your Honors, is that on the authority of Section 18.8 of the Interpretation Act, it says very clearly that if you do something under a specific enactment and it turns out that you had no authority to do it under that enactment, it is to be treated as having been done under the enactment that you're authorized to do it under. That's in effect what that is saying. And that is applied frequently in relation to decisions of public authorities where they invoke a particular power under a statute, and it turns out you don't have the power under that statute. And the effect of the Interpretation Act is, well, you are to be treated as having been made under a statute where you do have the power to issue the particular order.
It's a small point, Mr. Mendes, but I looked at this provision from your submissions, your written submissions, and I confess I could not see how an allowance which is made for a statutory authority is applicable to a private party unless you're saying it is by parity of treatment, reciprocity or something, but this...
No, Your Honor, the language itself is not limited to public authorities. It says, notwithstanding that a statutory instrument or a statutory document is expressed or purports to be made or issued by a person...
A statutory instrument or a statutory document.
Yes, and those are defined, if I may refer you to the definitions. Instrument is defined, it includes a proclamation, order, or warrant, other than order made or issued by the court. Notice.
But Mr. Mendes, all of these are documents issuing from a public authority or body.
No, Your Honor, if you look at the definition of statutory instrument, it says a statutory instrument is an instrument made under an act.
Right.
And statutory document means any document issued under an act other than a statutory instrument or an order of the court. So when a person issues a notice under an act, that is a statutory document or a statutory instrument being issued by that person. And if you then go back to the provision itself, it says, notwithstanding a statutory instrument, notwithstanding a notice, because it includes a notice, notwithstanding a notice is expressed or purports to be made or issued by a person under a specific enactment, notwithstanding, in other words, that this notice of appeal is expressed or purported to be made by Mr. Tasker under the Magistrates Court Act, it shall be deemed also to be made or issued under all powers thereunto enabling that person. So if that person had the power under the Extradition Act to issue that notice, then it is to be treated as issued under.
I promise I will look more intensely
Yes,
at this, but for right now, you have not moved me at all from my difficulty, but I promise.
Yes.
Yeah.
I'm terribly sorry as to that, but if I may take the point a bit further, Because that is, as you.
But you can make the argument that if that is given to a statutory body, then similarly, an allowance should be made as a matter of equal treatment to an individual who is seeking to bring himself under the power of an instrument. So continue, move on.
I appreciate that assistance. And the point is that the point is that if what is good for the goose is good for the gander, if public authorities can rely on this provision when they are making orders that might affect people's rights, then a person who is issuing notices like a notice of appeal under one enactment, they should have the benefit as well.
A resounding submission, Mr. Mendes. I think you can move on.
Thank you very much, Your Honor. But if I can also rely upon, in this regard, the rules
All right.
of the Supreme Court, which says an error of procedure or failure to comply with a rule, practice, direction, or court direction or order does not invalidate any step taken in the proceedings unless the court so orders. Where there has been an error of procedure or failure to comply with a rule, practice, direction, court order, or direction the court may make.
I can relate to this one though. This is 26.4
Yes.
of what?
And if I can
Of the Interpretation Act?
No, this is of the rules of the Supreme Court.
I see.
And if I can take you to, in that similar vein, the decision of this court in Watson against Fernandez, where the court says that courts exist to do justice between the litigants, though balancing the interests of an individual litigant against the interests of litigants as a whole in a judicial system that proceeds with speed and efficiency, as we made clear in the Marchandani case. Justice is not served by depriving parties of the ability to have their cases decided on the merits because of a purely technical procedural breach committed by their attorneys. With great respect to the court below, we disagree that there is anything in these rules to suggest that there is a time limit on the court's ability to excuse non-compliance with the rules or permit it to be remedied if the interest of justice requires. What we're respectfully saying is that there is an attempt by Mr. Tasker to, let's say, comply with the directions given by the magistrate. He acts on the advice of his attorneys, and instead of making the application for leave to appeal to the Court of Appeal, he files a notice of appeal. And the evidence is that the lawyers intended it to be under the Magistrates Court Act. But it is a document that says notice of appeal. We're respectfully submitting that, consistent with what I have just read, the court ought not to shut the door on Mr. Tasker because his lawyers followed the wrong procedure. The correct procedure was to apply for leave to appeal. They didn't do that. They eventually tried to do it, but it was late. We respectfully submitted in those circumstances. Do the necessary corrections to the notice of appeal that is before was before the court. Treat it as an application for leave to appeal. Forgive the procedural irregularities so that Mr. Tasker can be given full access to court that the Constitution entitles him to under the protection of the law. And that is essentially what we are saying. Treat that notice, filed in time, as an application for leave. Apply the rules which say that even if you don't follow the rules which say how you make an application for leave, we are not going to shut the door of justice on you, and the parties are not to be made to pay for the errors of their lawyers as far as that is concerned.
Is there a form prescribed by the Extradition Act?
None whatsoever.
None. And when the Court of Appeal met to consider his appeal, was the application for leave under the Extradition Act already filed?
It was filed but late.
I know, but it was filed before the court embarked on the
Yes,
hearing.
it was, yeah. There was an application filed about 2 or 3 days late it was filed.
About what?
2 or 3 days late. It was filed, the time for filing expired on the 23rd, I think it was of September. The evidence is that the parties were attempting to file documents on the 24th, so they were in any event late. But there were problems uploading to the system, etc. So it didn't eventually get onto the system until I think around the 29th of September, as it turned out. But the evidence was that they were attempts.
And the hearing would have
Point is
been
that their
sometime.
attempts were late in any event, is what the evidence
If
is.
we got to the point that you have now taken us to,
Yes.
what is it that you are asking of us? Are you asking of us directions to the Court of Appeal to hear the application for leave?
Yes. In other words,
And
treat the notice of appeal
Yes.
as the application brought within time, and therefore now to hear the application.
And the Court of Appeal would have the discretion whether to grant that application or not.
Yes, because then they would then begin to ask the question whether there is any merit to it, whether there are any arguable grounds that the magistrate went wrong.
Okay. Thank you.
Ms. Mendez, let me just clarify. You're saying you want the Court of Appeal to treat the notice of appeal as the application for leave.
Leave to appeal, yes.
So there would be no question of your being out of time, is that right? Okay, I understand.
Or alternatively, extending time
Alternatively,
to the one
extend the
that was
time.
filed on the 29th.
Correct.
Yes.
Alternative, and then in that regard, we rely on Dean against Allenby. We rely on the Culmer decision, and if I may just refer to that, this is what Sir Michael Barnett had said. This is after referring to Dean and Allenby. It says, it is paragraph 12 of that judgment, counsel for the intended appellate line. He said that although it did not appear to have considered the decision in Lucas West, which is the Omachowski case, it's the same case. The CCJ also came to the determination that limitation periods found in statutes are not absolute and must be read subject to the constitutional right of fair trial. The example of natural disaster is but one circumstance. The court must be careful not to limit itself. We're respectfully asking you to adopt that. The court ought not to limit itself to natural disaster.
What's this document from which you're reading?
Sorry?
What's the document from which you were
I'm
reading?
reading from the decision of Sir Michael Barnett in the Culmer against DPP case. You see it at
I see. Okay.
there. And then, of course, in that regard, we rely on the Pomachowski case, which was an extradition case in which the court indicated very clearly that it had to consider the question of failure to comply with the time periods for making an application for leave to appeal in the context of the right to a fair trial, but also in the context of the common law right to remain in the United Kingdom, which translated to Barbados terms, it's the constitutional right to
Section 22.
and also the constitutional right to remain in Barbados. So you see at paragraph 32, the court saying, in these circumstances, Mr. Halligan enjoyed a common or civil right to enter and remain in the United Kingdom. And then further down, the 2003 Act has the authority of Parliament. To that extent, Mr. Halligan's right to remain is potentially qualified. But under the Act, it's only through domestic extradition proceedings that this right can be effected and suspended for the purpose and period of any American proceeding and of any sentence which might thereafter be passed on him if found guilty. Insofar as the right may be suspended, the extradition proceedings determine whether Mr. Halligan may continue to enjoy his common law right for what proves to be a limited period. And then, if I may go to paragraph 33. In those circumstances, it follows, in my view, that the extradition proceedings against Mr. Halligan fell within Article 6.1, the equivalent of our 18.8 right to a fair trial. So far as proceedings involve under the statute a right of appeal against any extradition decision, Article 6.1 also requires that it be free of limitations impairing the very essence of the right, pursue a legitimate aim, and involve a reasonable relationship of proportionality between the means employed and the aim sought to be achieved in accordance with the standard identified in Tolstoy. If I ask you to look at paragraph 35, finality and certainty are important legal values, but although the cases to date may not be large in absolute numerical terms, they indicate that neither finality nor certainty has been achieved to date. Even on the more relaxed view of the statutory conditions, which I consider appropriate, the statute will be capable of generating unfairness in individual cases unless some further relief is available. More importantly, it's not sufficient under Article 6.1 if in most or nearly all cases the right of appeal can or should be capable of being exercised in time. The very essence of the right may be impaired in individual cases, and there may still be no reasonable relationship of proportionality. The court is leading up to the point where it says ultimately, therefore we have the jurisdiction to extend time in exceptional circumstances.
So
So they're saying, in other words, that the right of access to the court can be impaired if you adopt an absolute rule in relation to the time periods that are fixed. And you see in paragraph 87.
You're running up against time now, Mr.
I'm sorry, if I may,
Different
one
left
last
hand limit.
paragraph. Paragraph 39. In the present case, there is no reason to believe that Parliament either foresaw or intended the potential injustice. It intended short and firm time limits, but can only have done so on the basis that this would in practice suffice to enable anyone wishing to appeal to do so without difficulty.
15 minutes.
In those circumstances, I consider that in the case of the citizens of the United Kingdom, like Mr. Allergen, the statutory provisions concerning appeals can and should all be read subject to the qualification that the court must have a discretion in exceptional circumstances to extend time for both filing and service, where such provisions would otherwise result in a manner conflicting with the right of access to the appeal process. The court must have power in any individual case to determine whether the operation of the time limits would have this effect. If and to the extent that it would do so, it must have power to make a in or out-of-time appeal, which the litigant personally has done all he can to bring a moot. So for the reasons that I've given earlier as to why these are exceptional circumstances, we respectfully submit alternatively that the time should be extended.
One small point occurs to me, Mr. Douglas, and it may or may not be all that relevant, but surely the extradition arrangements between, in this case, Barbados and the United States are governed by international treaties.
It's governed by the Extradition Act primarily.
Yes.
Local proceedings for extradition governed by the Extradition Act. But there are obligations set out in the treaty as well.
Between the two states?
Yes.
Yes.
For example, the specialty rule is not in the Act in relation to the United States, but it's in the treaty.
Mm-hmm. Now, what I'm trying to get at is, I'm just wondering aloud, because I haven't researched the point, whether there's anything in the extradition treaty that is relevant to this question of the procedure for appealing from a decision of the magistrate for extradition.
I will check. I don't know the answer right off, but even if it did, obviously the Act would take precedent. Whatever the procedure is under the Act would take precedent.
The Act does not expressly incorporate the treaty.
No, it doesn't, because it applies generally to a number of different Commonwealth and non-Commonwealth.
Mm-hmm.
And there is, I'll double check, but I read through the Act yesterday, and I don't recall seeing any provision incorporated.
That could be relevant. Mm-hmm.
I take it, Mr. Mendes, you'll be saying in any case that the rights under the Constitution would be overarching.
In any event.
In any event, even if there were specific provisions in the treaty for certain things. Yeah.
That is correct. Yeah.
Yes, that's it, Mr. Mendes.
Much obliged to Your Honor.
Thank you very much. Mr. Seals?
If it pleases this honorable court, I rise to respond to my learned friend's submissions.
Oh, yes. Could you please come to the podium?
The respondent submit that in answer to the questions that this honorable court asked, we agreed that this court has the authority to reopen this application. The apex court and the authorities, all the authorities point to that fact, that as the apex court, this court has the authority to reopen such applications. Secondly, the other question was whether in the event the court is minded to grant this application to reopen for special leave, the decision to refuse the application for special leave originally filed on the 11th of May should be reversed. And we humbly submit that it should not be reversed. Why we say that is that there are no special circumstances that would merit this reversal. My friends, in their interpretation of the rules, indicated firstly that the rules precluded them, so to speak, from having a hearing. And there was no provision, so to speak, for that. My understanding of the rules, when we look at Rule 9.7, it indicated that applications which may be dealt with without a hearing. And it says that the court may deal with an application without a hearing if no notice of application is required, or the court considers it appropriate to do so. That's B. C, the court does not consider that a hearing would be necessary. And it goes on to D and C, which are not an issue. But this court has the authority that if it considers it appropriate not to do so, and it does not consider that a hearing is necessary, then this court can make that decision. And that stems from, although my friend interprets it differently, 1014.
Before we go to 1014, though, wouldn't you say that what you have read so far is referring to an oral hearing?
Yes.
Okay.
And there's a gray area in relation to the opportunity to provide written submissions.
Yes. I'm
But
saying,
as a rule of natural justice,
I'm not hearing you, sir.
pursuant to the
Yes.
rules of natural justice,
Yes, sir.
you would agree that the applicant must have the opportunity
To be heard.
to be heard.
Yes, please.
And that can take place either by virtue of a written hearing or an oral hearing.
Correct.
Would you agree? Okay.
Agree. And that is what takes me then to 1014, which I humbly submit requires the applicant to give the court sufficient for that court to make a determination. As the court, when we considered the overriding objective at 3.1, which really states that just let me get it. When the court makes this court is supposed to manage its matters and determines then what matters it will hear. And you have to sufficiently move the court for the court to hear something from you. So it is necessary for you to give the court something. You can't just give an apex court any old thing and then expect the court to hear you. You have to write or submit something sufficient enough for a court to make the determination whether or not that court will hear you.
Yes, please. As Mr. Mendes went through it, where in 1014 does it tell the litigant that in the application for special leave,
Yes.
they must send in their legal submissions?
I didn't say that, sir. It doesn't say that in
So that
1014.
there is no provision.
There's no provision,
in the
and I accept that. But I am saying,
And therefore,
sorry,
1014A that speaks about the likelihood, or at the very least, the possibility about your arguments, is that is later, that is subsequent to the application for leave.
yes, it is.
So the argument that is being made by Mr. Mendes is that a litigant looking at that rule could take the view that I will be invited at some stage to make written submissions at least, or to a hearing, to an oral hearing. Don't
That's
you
correct.
agree with that?
But in any event, it still must come to the level, the threshold that the court would invite a person looking at when one determines whether or not special leave was to be granted. It would still require a litigant to reach a standard, something that the court can read, something that the court can make a determination whether or not that special leave will be granted.
You see, 1014B, by limiting itself to facts, is problematic
Okay.
because facts do not include legal submissions.
That's correct.
Facts relate to facts. So that while you should set out all the facts that may be necessary in order to enable the court to determine whether special leave ought to be granted, a litigant can reasonably believe that I do not yet need to set out all my legal submissions sufficient to determine whether special leave ought to be granted, because at some subsequent stage, I will be invited to do so.
In fact, Mr. Mendez might go further and say that he's not authorized to submit anything else but facts, because that's what the rule says.
Because that's
Yes.
what the section, that's
Yes.
what the rule says.
Yes.
So where does that leave your defense, your reply, your response to the view that the applicant here could feel reasonably aggrieved that they didn't have an opportunity to make at least written submissions?
I take your point.
Okay.
The question then still is, the following of the rules as it relates to the Extradition Act.
Yes.
Because having been told at the date of committal the procedure that must be followed, and a party, and I call it, I would say the litigant, and I will try to make the distinction between the litigant because my friend does that. The litigant does not follow the requirements, which in my opinion are very strict. And I believe that they are strict for a purpose, in that extradition treaty, the process of extradition, although it must observe the rights of the individual, and they must follow all the practices applicable to the individual's constitutional rights, they're still done they're still expected to be done expeditiously. This court itself, in the ruling, which my friends seek to reopen, is important, and it speaks to this at paragraph 24 of Alex Tasker and the United States of America. When it says the argument of the Court of Appeal had the power to enlarge the time for filing of the application for leave under the Extradition Act also appears problematic. It says, nowhere in the Extradition Act is power given to the divisional court, now the Court of Appeal, to extend time limits for the filing of the application for leave to appeal. The decision of the drafters not to explicitly grant this power to enlarge the time is consistent with the objectives that extradition proceedings are to proceed promptly and efficiently. It doesn't ignore the rights, but it's supposed to proceed promptly. So when the time frames are set out as to be followed, and it basically says, as at committal, obviously, the learned magistrate did tell the parties what they could do. They may, under law, apply for leave to appeal or apply for a writ of habeas corpus. And he did inform the party of that. Having not done that, and gone in a particular direction, which my friends now seem to suggest could be taken to, the intention of an individual to appeal is now to be taken as to if he has actually appealed, or if he has gone in another direction, oblivious of what the court has told him or flouting what the court has told him, it should still be taken to mean that he intended to. That must still, in my opinion, be the problem. Because the question is, and I ask this, when at Section 20, the Extradition Act says, with leave of the divisional court, an appeal lies to that court on a question of law only from the committal to prison of a fugitive or the discharge of a fugitive under Section 17. When my friends suggest that, one, you can accept the procedure adopted by them pursuant to the Magistrates Court Act and treat to it as if the intention to appeal was an appeal to the High Court. The question is, how do we look at it if it were the other side? The rules are there for both. And my challenge is that what I am hearing is when a mistake is made by counsel for an applicant or what should I say? Anytime we are talking about parties to a matter, whether it be the applicant or the defendant, but especially in this case, we're talking about the applicant. When mistakes are made, then that litigant is divorced from the mistakes of his counsel. Is it the same when the mistakes are made by the state? The state and all of its agencies are regarded as one. And this right that accrues, and I only this morning, I heard this court said something in the decision just given by James Fields, as it relates to James Fields. And at paragraph 44, this court said, and I quote, "At the same time, however, there is no good reason in principle to treat the witness for the defense differently from the witness for the prosecution with regard to the directions on how the jury should deal with discrepancies or inconsistencies in testimony. To the extent that there is any suggestion of a distinction between witnesses for the defense, other than the accused, and witnesses for the prosecution would suggest that this distinction is wrong and should be discontinued." Basically, it is saying, this court is saying, you in this balancing act, certain rights cannot accrue to one litigant as opposed to another litigant.
But why are you assuming that a court will make that distinction in a case of this nature?
Why am I?
Why are you assuming that a court will make that distinction in a matter of this nature? In other words, I understand fully your argument, but it seems to rest on a premise that if, for example, the shoe is on the other foot and the state was seeking leave to appeal but had issued the wrong document, that there could be no argument, because it is the state, that the Court of Appeal should extend time. You understand me?
I'm understanding you. I'm understanding you very clearly, sir. But well, obviously, I am saying though, certainly, if without the court, if this side had done that, I am sure that certain issues would be raised by my learned friends. Certainly, not the court.
Just as you're raising the issue.
Just as I'm raising the issue.
At the end of the day is what would have been the proper position for the court to take.
Exactly. So I need your leave.
Sure.
And I wanted to just extend that argument by making reference to one of the authorities that my friend relied on. The Pawłowski case, this, I call it the Polish case because there were 3 Polish persons involved in this case. And
Remind me the page number again? The CCJ page.
the CCJ, 1646
Yes.
is the CCJ's case, but the reference I want to speak to specifically is Baroness Hill. Baroness Hill's part of the decision.
Can you put it up, Mr. C? Thank you.
Sorry for my highlighting also.
That's all.
Great apologies. This was in, as it relates to the same extradition, and I would want to speak to this case a little. First of all, having read the case, and I hope I understood it, that this case was about Polish persons who they sought to extradite. One, I look at it and distinguish it from the present case simply because when I read the procedure, these persons were arrested one day. In most cases, they were taken to court shortly thereafter. In one case, it was about 2 days after, the other one 3 days after, but quickly. And their procedure allowed for the magistrate then to commit them for surrender almost immediately. Sorry, he recommends to the Secretary of State who decides whether the person would be committed for surrender, which is a little different to our procedure. But in these particular cases, these men came before the court, were hustled before the court after arrest. They had no hearing. They had no, from what I read in the facts, these men had no hearing. They had no opportunity to ventilate anything about the case, but were recommended to the Secretary of State for extradition. Clearly, one would bring issues of procedural fairness there, opportunity to be heard, as opposed to the matter which is presently before the court, whereas this matter was ventilated before the learned magistrate over a period of almost 1 year. But in any event, when the Baroness spoke about this, she did say, and this is just to bolster what I indicated about the fairness. At paragraph 51, she says, however, it does seem to me unsatisfactory that we are taking this course rather than the more straightforward course of departing from Musili. 2009, 1 Weekly Law Reports at 276. There is very good reason to think that the House decided Musili on a mistaken factual assumption. There were good reasons, trenchantly, expressed in Lord Rogers' dissenting opinion to think that the intention of Parliament was to insist only on filing rather than on service of the notice of appeal before the deadline. For my part, she said, I consider it more satisfactory to comply with the actual intention of Parliament than to resort to the obligation of conforming interpretations, whether under the European Communities Act 1972 or the Human Rights Act 1994. This part is more important. Paragraph 52 said, resorting to Section 3 of the 1998 Act, although two of the parties consider this possible, produces two distortions in the extradition process. It discriminates between nationals and aliens. It also discriminates between the requested person and the requesting authorities. For the latter can have no convention rights, which mandate a compatible interpretation. Thus, Section 24.
Could you bring it down a little or up, as the case may be? Yes, thank you.
Thus, Section 28.4, Sections 105.5, and Sections 110.5, which impose, and these were about the process of extradition and the warrants and all of the attendant things, which impose the same time limits upon appeal against discharge by the first instance court or by the Secretary of State, cannot be read down so as to forgive such trivial failures as these on the part of the requesting authorities. And that is the reason why I'm saying that when we look at this matter, the issue before the court, I would suggest, is the exceptional circumstance. If we cut through all of the other things, my focus would be, and I hope I am correct, that we look at exceptional circumstances. What are the exceptional circumstances that will cause a court to extend time? Firstly, even if it didn't have, because if it doesn't have jurisdiction, that's a problem. And I still believe, I humbly submit that that's a problem. That you can't just simply flout the rules and we say as a court, okay, you intended to. So simply mean that we would accommodate you. There are rules that govern the court, and there are rules for a particular reason. One anticipates that there will be circumstances where the rules may not be followed or cannot be followed, and that is where the exceptional circumstance comes in. And that is why in all the authorities I read, the circumstances, exceptional circumstances meant something like, natural disasters. These were things, and they were not the only things, but if we say, okay, let us not be constrained by natural disasters. Give this a wider interpretation. I don't think that we can move the threshold that's supposed to be reached from natural disasters to a mistake on the part of a lawyer. I think that is really lowering the bar that you can crawl over it. It must be something that is exceptional. And although I do agree that to limit it to natural, there may have been other things. But it must be still up there with those things. A simple outage of electricity on the last day of filing, that's not a natural disaster. But at least that is something that may inhibit the filing, especially in this age of technology when we are using electronics and for the purpose of filing. So to me...
And you're saying that the client's rights in those circumstances would suffer?
Yes.
Yes, but that would still not be justification for the extension. That would still not be justification for extending time.
If electricity went off?
Yes.
No,
Yes.
No, I'm not saying that.
Oh.
No, I am saying that if we look at exceptional circumstances, Your Honor, and exceptional circumstances is the threshold of a natural disaster.
Yeah.
And we can't limit it to that. There must be other circumstances.
Yeah.
I bring it down to even electricity power outage island-wide.
Mm-hmm.
That would be an exceptional
Yes,
circumstance.
please. I am suggesting that even that can be an exceptional circumstances. You don't need to stick to these things that are, and that's not a natural disaster.
Mischievously, Mr. Mendes would say to you that if instead of there being a power blackout, there was a perception blackout on the part of the lawyer, then it is the equivalent.
No, no, certainly that would be the stretch that I speak about.
All right.
Your response to it that it is human to err, and therefore human error is
Human error
After the
certainly
course.
cannot, in my opinion, in my humble opinion, human error simply cannot reach that threshold.
Yeah.
Mr. Steele, are you at all sympathetic to the notion that, look, as I think this court said in Watson and Fernandez, and repeating Chief Justice Wooding, courts are there to do justice between parties and not to win little technical points. And if a person is out by 3 days in a circumstance where the consequence is a denial of a constitutional right, a possible denial of a denial of a constitutional right, the right to a fair to a hearing, that's not an exceptional circumstance.
I humbly submit, no, it is not. Because 3 days, and this is where I have a little difficulty, is where is the cutoff point? 3 days, and that's why I believe we have rules and why we try to follow the rules. Because the question is, when one exercises one discretion, or the court exercises its discretion, and it says, all right, you're out by 3 days, it's not so bad.
But that then would become an issue for argument at the Court of Appeal and not here. Am I correct? In other words, as I understand Mr. Mendez, he's not asking that this court should extend the time, but rather that this court should have the Court of Appeal assess all the points that you are now making.
I think the issue will still come back to the same. When the issue, if he's not asking this court to extend time, then by inference, he's still asking the Court of Appeal of Barbados to extend time. Because the only way the Court of Appeal will be able to hear is if time is extended. There's no other way, because the procedure that they embarked on certainly can't be regarded as being before the court, having gone through the Magistrates Court Act. And the problem also I have, and this issue, is that the court, the Barbados Court of Appeal really was not confronted with the same issues that are before this court. Simply to put it, is that when we went before the Barbados Court of Appeal, at first they were arguing that they were within time.
They were arguing that
They were within time. And that is where the affidavit came up of persons suggesting that they tried to file and they didn't get it done within the time. I think it's that paragraph 52 that the court said it wouldn't get into it, because I queried it and said, well, but the affidavits are on the 29th, dated on the 29th. So how could you say that you tried to file before that when the applicant's affidavit itself is on the 29th, which is out of time? And there were arguments as to how they tried to file, how it was rejected by the clerk, how they didn't use the ones that were filed within time because they had errors. And I raised the question respectfully, if your if your documents that are filed within time have errors, why would you destroy them? Because that was the response, that they filed within time, but they destroyed them because they had errors. And I said, well, this is the evidence that one would want to prove that you filed within the correct time. You would keep those, even if you filed the ones that were amended afterwards. The court, as I said, didn't embark on a discussion with that. But the court below was confronted with these issues, which to me are kind of different from the issues that we now face. It seems now that we have now accepted that they were out of time, as opposed to what the court below had to deal with. And that is kind of my challenge, sir, because I understand that when you are appealing from a court below, it is basically the issues that you've canvassed there, even if added to, but the same major issues, as opposed to saying, well, it's a different thing. You've abandoned now the issue as to whether or not you were in time, and before this court now is something else. We are saying to ourselves now, this is, even if we were out of time, we should still be allowed. And that is where the issue of exceptional circumstance raises its head. And I am saying that although I stand on the submission that the court had no jurisdiction, that to hear Dean and Allenby, that was a magisterial appeal. So basically, even if certain things were not done within the purview, within the perimeters of it, it was a magisterial appeal. So the court then still had jurisdiction to deal with the matter, whether extended time or not. The extradition now is somewhat different. And if the court has nothing before it by way of the extradition appeal process, the 15 days that one should follow, then the court can't take cognizance of it. That is my submission. But going past that, even if it were to, then we look now at the exceptional circumstance. Because I humbly submit that if this natural disaster or things akin to that had happened even in these circumstances under the Extradition Act, that a court would still have to find a way to deal with it, because then that would have been a circumstance beyond the control of the parties. So certainly, I hold the view that we would allow some form of extension in circumstances where this exceptional circumstances occur.
Could I take you? After you, my brother, please.
Thanks very much. Yeah, I was just wondering if you are limiting exceptional circumstances to cases of force majeure. I mean, you don't think it could exist outside of that? Hurricane, earthquake, or something of that nature? Do you think that we should restrict exceptional circumstances so narrowly?
Honestly, I believe so. Why? If there are rules governing time to follow these things, and it is extended to almost any conceivable circumstance, including the fall of the attorney, the flouting of the rules, I think it opens the floodgates to say to persons, well, I am within that. I can find my way, because to me, when one speaks about discretion, because this is obviously a matter when you're talking about exceptional circumstances, you'd have to convince the court. And it will have to be a court exercising its discretion. If discretion then is so wide that it encompasses almost any circumstance at all, then anyone will find himself within that purview. And anyone can find themselves
Making the argument.
making the argument.
Yes, but Counsel, that doesn't mean the argument will be accepted. I think that's what the President was pointing out earlier. So the argument is made to the Court of Appeal, but that does not mean necessarily that the Court of Appeal will accept that these are exceptional circumstances warranting the extension of time.
Correct.
Yes.
But what I'm saying is, if this court, for example, if this court does not make certain pronouncements on what it may view as exceptional circumstances, and persons go before the Court of Appeal rightfully thinking that, or all right, I come within this, especially in a circumstance like this one. Litigation in this will never stop, basically. Because after I've gone to the Court of Appeal now and I've said to the Court of Appeal, oh, I fall within that group, and the Court of Appeal says no, then I come back to this court to say I want special leave to argue that I should have been in that group. Because there's no set bar as it relates to what are the things. I don't think it can be an exhaustible list, certainly not.
I think sorry to interrupt. No, I was going to say, I think your point is very well made, quite emphatically as well. I wondered if you would permit me to take you in a slightly different direction.
Yes, sir.
Counsel on the other side raised the issue of the Constitution, and that the Constitution has certain implications for the right to be heard. Were you intending to address those arguments?
Yes, I can, but what I say is, when you're talking about the right to be heard, I agree. But the question is this right without exceptions? First of all, in the first instance, and I'm just going to take this case, for example. In this case, you had extensive hearing in the first instance. Second, and that distinguishes it from Paucescu, as I said. Secondly, you seek leave to be heard. First of all, it restricts what you argue, because you are on a question of law only. You are arguing the act itself restricts you to argue it to questions of law only, and you seek leave. So a court must still determine that we will grant you leave to argue whatever. Your right to be heard will be addressed when you seek leave.
Mm-hmm. So the scheme anticipated, certainly by Section 20 of the Extradition Act, provides for that right to be heard within a reasonable period of time consistent with the constitutional guarantees.
That's correct.
Okay. Counsel also mentioned a number of other constitutional provisions which he said were relevant. The prevention of freedom of movement, I think, Section 22. I think he also spoke about protection of the right to personal liberty, Section 13. And again, I wondered whether you had any responses to those arguments.
Section 13.
Yes, I think he mentioned that, and he also mentioned 22. One of the things that occupies me is that those sections also reference extradition.
That's correct.
And reference the fact that the guarantees given there are, in fact, subject to some extent to the rules regarding the removal of persons from Barbados pursuant to extradition requests.
That's correct.
So I just wondered whether you had any responses to those points that he made.
Well, I will follow the dicta in Scantlebury. Sorry, I can't use the screen. I was trying to find the thing in the CCPS. Oh, the citation. Okay. And following the dicta in Scantlebury, it says, these issues, and starting here, these issues were for determination at trial. Further, 1951 Barbados. These issues were for determination at trial. Further, the specific right, it says, to examine witnesses guaranteed under 18(2) of the Constitution did not apply to committal proceedings for extradition. Moreover, the Extradition Act of Barbados was not inconsistent with Section 13, the right to personal liberty, and sections 22, the right to freedom of movement of the Constitution. The derogation provisions contained in these sections recognize extradition as an exception to the specific fundamental rights provided for therein. And I humbly submit that it is not, in our submission, inconsistent with the Constitution. There was another bit of the Constitution that my learned friend alluded to, which had me a bit confused, I must say. I could not find his interpretation, and that was it. I don't remember the exact section, but to me, it was trying to, when it was speaking about public authorities, it was trying to squeeze it to me within that definition to suggest that what was filed could be considered as a notice simply because
It was section 18 of the Interpretation Act, but you went on and cited other material which provided equally for non-public authorities what section 18 provides for a public authority or a person making a statutory instrument.
Grateful to you, Your Honor. But I couldn't see how all of these specific things that we have under the Extradition Act, as we have said before, and I'm sure the court well knows, I think the court even said it itself, this sui generis nature of the Extradition Act. It doesn't mean that rights can be trampled. It doesn't mean these types of things, but certainly it proceeds on a notion of reciprocity. It also proceeds on the notion of having things done efficiently and promptly. It does not allow for processes to be dragged out with ad infinitum. That's my opinion. But whilst doing that, recognizing the rights of the individual. And I am of the view, and I submit, that in this particular circumstance, that one, the avenue that the applicant adopted certainly does not allow the Court of Appeal of Barbados to countenance the appeal or what he intended to be appealed, because the rules, in my opinion, are strict. And although there is some leeway, so to speak, for certain things in certain circumstances, this does not fall within it.
I know you have passed it, but would you mind just going back and citing for me the provision or the paragraph in Canterbury that you looked at earlier? I missed the citation.
Just a moment. Oh, Scantleberry. Again, we have just. I may have closed the page. Just Craig records indulgence. The one I spoke about just now. Which one that was? That was to me. Just give me the same page. Craig records indulgence. Terribly sorry for this issue. Yes.
This has been filed in the record.
This is in our record. Filed in our record too.
Do you have the CCJ page number?
Yes.
I know.
CCJ page number. 1951, Your Honor.
Sorry, are you called Scantleberry?
51?
Canterbury, the Attorney General.
2009.
Oh, is it different in your,
Page 1951, is that what you're saying,
The record?
of the record?
yes, please?
Oh,
I thought they said, I thought it was a year you were giving.
No.
No, no, sorry, sir. No, sir.
All right, thank you.
yes, thank you.
But what you read from was the head note earlier, Mr. Seal.
Yes, this way.
Yes, but I don't think we need to trouble you further on this. We have very good detectives in the CCJ, so we can track it down quite easily. Thank you very much.
Great, great. So as I close, basically, unless your honors wish to hear anything specifically from me, I maintain that the right to be heard is still subject to certain conditions. In many cases, Lavelle, even Van der Pijl, the court at that stage refuse leave in certain circumstances. And I'm saying in this particular case, I recognize the rights of the individual. I understand the duties that a court may have to the litigant, but I do not think that we can lower the bar to an extent which allows any reason for not complying with the rules to be regarded as an exceptional circumstance. That's my
Am I correct
difficulty. Sorry, sir.
in saying that the Court of Appeal actually did not think that it had the power, whether exceptional circumstances or otherwise, that it simply did not have the power to extend the time, and that they relied on two cases, Watson and Webster.
Yes.
So that they never even considered, they did not consider whether there were or there were not exceptional circumstances. They interpreted the act as though the 15-day period was a guillotine, and then thereafter, they had no power.
That's correct. That's correct. And I am of the view that those timelines given in the Extradition Act should operate as a guillotine, so that persons will comply with all the requirements. Because if one were to examine these exceptional circumstances, the guillotine, in my opinion, would still come down on the side of the state, because this is one that will not fit squarely into exceptional circumstances. Because I think that is the issue here in my humble submission. Since we are not at odds with all the first point, the issue here is whether this court should reverse the decision. And I am of the
But you see, there's a little discrepancy here, and I think Mr. Mendes' position is that the applicant, as I understand it, is not asking us to determine that there were exceptional circumstances and therefore the man's appeal or notice of appeal should be granted. The man's leave to appeal should be granted. But rather he's saying to us that the Court of Appeal was in error in thinking that they had no power whatsoever in any circumstance to extend time. And therefore, this court should not agree with that finding and ask the Court of Appeal to consider whether there are circumstances here that warrant them to accept that they do have the power to treat with the application for leave as they see fit, which would include them making the arguments that you're making now, accepting the arguments that you're making now, namely that it's human to err, human error can't be considered an exceptional circumstance. And while the CC just sent this back to us, we are finding that, okay, we do have the power, but this is not a particular instance in which we should exercise that power in a particular way.
Or the opposite, of course.
Or the opposite.
My response to that, Your Honor, is still that from documents filed, there was nothing before the court that, in my humble submission, that the court could then consider these things.
You uphold their view that they didn't have the power given what was before them.
What was before the court? That is my submission.
Yeah.
That is my view.
Okay. Thank you.
Unless this honorable panel wishes to hear me further.
Thank you.
I'm obliged,
Yes,
Your
thank
Honor.
you very much. Mr. Mendes, you want to say anything?
Yes, and Mr. Mendes, I think for my part, I would appreciate some clarification in how far you're asking us to, because that is, to me, is where, I need.
In fact, we had asked the court to treat the notice of appeal as an application for leave brought within time.
You see, this is it.
So that's the first thing.
At one time, I thought that you weren't going that far.
Yes, so we in fact ask you to do that. And we have said that in written submissions, and I repeat.
I see. So that
We're asking you to treat it.
I misrepresented your position just now.
Well, the latter part, we are saying that one, either treat it as having been filed on time, treat it as an application for leave filed in time, because it was filed on the 8th of September, or alternatively, extend time. So we are saying that what has happened is that the Court of Appeal thought that it did not have the jurisdiction to extend time, and therefore it didn't even consider that. So we are saying they are wrong, and
My thing
therefore
is,
we are asking you
isn't that
to
a
extend time.
discretion which
Resides.
Court of Appeal really should exercise, and in the circumstances, not this court?
Well, let me put it this way. If you are not with us on the question of treating the notice,
That's your fallback position.
a fallback position is we're asking you to extend time. Further fallback position is, at the very least, we have not yet had a consideration by a court as to whether time should be extended. Therefore, if you do not think it appropriate that you should do so, then send it back to the Court of Appeal so that they could consider that. But the point is that if that is the case, and let's assume they don't.
Sorry, let me interrupt you just to get clear.
Certainly.
Did the Court of Appeal pronounce upon the treating the notice as an application to extend time? Sorry, as the application for leave.
They dealt with it strictly on the basis
This is of-
whether you can apply to the, whether you can appeal under the Magistrates Court Act.
Right, and therefore, right, so therefore, the Court of Appeal dealt with it on the basis that we have no jurisdiction to extend time.
At all. So therefore, they then went to the next stage, well, we have an application for leave to appeal, and they said we don't have jurisdiction to extend time. And that was it, full stop, guillotine.
Right, so
But
they,
to the extent, I'm not too sure if my learned friend was suggesting that the argument was not raised in the court below, but in fact, in the written submission in reply, you'll see at page 453 of the record, in fact, the Polish case that my learned friend referred to, it was referred to in written submission. So that it was there, but they did not consider, well, they didn't address the argument in any event on the basis of the Polish case. They just simply said they had no jurisdiction. The point I'm making, Your Honor, is that the reason why we're asking you to determine it is because if the matter is sent to the court, either side will have a right of coming back to you for you to consider it again, whichever way the court goes on the question of extension of time. I refer you to the decision of this court. I think it's different. In the BCB Holdings case, I think, in which the Belize Court of Appeal had decided it on the basis that the law was unconstitutional. The court reversed that and then went on to consider the question whether the arbitration award was contrary to public policy, even though the Court of Appeal did not express any view in relation to that point. So you consider the argument. In those circumstances, we're asking you to do a similar thing here.
Mr.
I'm saying
Bennett,
that to answer your honest question, yes, we are asking you, in fact, to determine it.
yeah, Mr. Bennett, the little difficulty I'm having with the treating the notice of appeal
Yes.
is that I don't suspect the notice of appeal, as bare as it is,
Yes.
would give you much to argue in the Court of Appeal. All you're saying is that the decision of the magistrate is erroneous. I imagine application for leave to appeal would have a lot more substance.
Yes, but then, of course, we would be asking the court for leave to amend the application, if you treat it as an application, in order to flesh out the grounds of appeal. So yes, it is deficient, there's no doubt about it, in many respects, in that it is not on the face of it an application for leave to appeal, and on the face of it, it does not contain all of the grounds. But again, I don't want to go through the arguments again, but the rules say that we are not out of court because of procedural irregularities, and the Watson case against Fernandez says that, again, it's not a game. We want to come to court to argue these matters and allow us to do so. And the court can always make, as the rule says, the court can make orders in order to correct the deficiencies in procedure, which would include set out your grounds of appeal and so on.
Because what I heard from you at the first instance, Mr. Mendez, and I mean this morning,
Yes.
was that you wanted the Court of Appeal to hear you on the merits.
Well,
That is what the litigant wanted as far as you were concerned.
Because what we're saying is that if you treat it as an application having already been made within time, or you extend the time, whichever, then the application for leave will have to go back before the Court of Appeal, but not an application to extend time, but it will be treated as a valid application for leave, and then the Court of Appeal will consider the merits of the application. And then they will get into the question.
If it goes back to the Court of Appeal as a perfected application for leave to appeal,
Yes.
the Court of Appeal would still be within its rights to grant the application for leave to appeal
Yes.
or not to grant it.
Yes, but then they will be considering the merits of the case, that is to say, whether the magistrate complied with the Extradition Act.
It wouldn't really be merits,
No,
it would be
sorry,
the merits
sorry.
of the application.
The merits, yes, the
The
merits of
application,
but
yes.
Part of the application would be to demonstrate to the court that
Yes.
there's an arguable case.
You would demonstrate on the leave application that there is an arguable case.
That's correct, yes.
That would not be for the determination on the leave application.
They will determine whether there is an arguable case.
Oh,
That
all
the
right.
magistrate went wrong.
That clarifies it for me,
Yes.
thanks.
For me too.
Mr. Mendez, what's the difference between what you're asking for and a complete relitigation of the case again?
A complete, sorry?
Relitigation.
Well, we haven't yet gotten the opportunity to persuade the Court of Appeal
Because
that
of
there
your-
is substance
because of
in our
yourself.
challenge.
No, because of no one but yourself.
Absolutely. There's no one but, well, the representatives of the applicant. The applicant, we are saying, is dependent upon the, Your Honors, I'll be going through the argument again. But the point is that that is the predicament we find ourselves in. But I'm relying on the fact that the applicant was trying to get to the Court of Appeal in order to argue that the magistrate went wrong. And because of procedural irregularities, he wasn't able to get there. But I've recited all of the cases that say that that ought not to
Mendez,
prevent him from doing so.
You're referring to it as procedural irregularity.
Correct. In other words, it had nothing to do with the substance of the matter.
That's
the
right.
merits of the case.
That's right. But I raised the question with you earlier as to whether this was not a lot more profound than a procedural irregularity and whether it didn't go to jurisdiction.
Your Honor, the applicant is seeking to invoke the jurisdiction of the Court of Appeal. He has done it in the wrong way. done it in the wrong way
So
because...
he hasn't done it then?
No, he's done it in the wrong way. And the rules say that you will be forgiven for procedural irregularities. That's what the rules say. The rules and the court has said you will not be driven from judgment seat, as it were, because of errors made by lawyers in procedure. The court, in other words, the court is concerned to determine matters on its merits. And the court in this case would be concerned that a citizen of Barbados is not being sent to be tried in a foreign country in breach of the Extradition Act. In other words, without having had the opportunity for the court to determine whether it is in accordance with the Extradition Act. That is the danger, and that is a danger that is being pointed out by the UK Supreme Court in detail in the Polish case. That is what we're all concerned about, to ensure that you have an opportunity to make the points and you're not derailed, as in the Polish case, because the notice of appeal was not served on time. It might have been filed on time, but not served on time, even though the law says that you must do both. That is what they were concerned with. And again, it's the jurisdiction of the court can't be invoked unless you comply with those time periods. And the court is saying we can't treat that as a guillotine. And we have to remember that we're dealing with constitutional rights to a fair trial, and therefore the rules have to be construed and applied consistent with those constitutional rights.
Okay. Yeah.
If I can just address one point very quickly, my learned friend was having a discussion with you as to how you would frame the exceptional circumstances, and he's saying natural disasters, nothing else. The Court of Appeal of the Bahamas is suggesting that the test should be this way, as you will see here at this bottom page. He said, only likely to permit an appeal outside the statute where the appellant personally has done all he can to bring the appeal timeously. So that is the broader test that they're seeking to apply. Of course, if there's a natural disaster and you're trying to file your appeal, then you've done all you could. But of course, there may be a natural disaster and the applicant made no effort at all within the period of time. In other words, it's not the natural disaster that was the cause, but it was the failure of the applicant to do anything at all. So there's still a requirement to show I have done everything that I could do. And that is what the Polish cases deal with, is insofar as the failure the failure to do what is necessary within a period of time is not the fault of the applicant, it's not his personal fault, but the fault of attorneys who failed to do what was necessary to be done. And this is what we are saying. In this case, the applicant has done all that he could personally do. This said appeal, yes, I'm given instructions to appeal. I am now dependent on my lawyers to do it the right way. So he has done all that he can personally do. And that is the broader test that the Bahamian Court of Appeal has put forward. And this is the test that we ask you to adopt and to apply to the circumstances of this case. And in that regard, if I can just remind you of what the UK Supreme Court said in the Komitowski case. The problems of communication from prison with legal advisors in short permitted periods of time and 14 days are almost bound to lead to problems in individual cases. There is no satisfactory answer that a person wrongly extradited for want of an appeal as a result of failings of those assisting him might perhaps be able to obtain some monetary compensation at some later stage. Strict application of the surrogacy principle would be potentially unjust. I am not persuaded that the interests of finality and certainty outweigh the interests of ensuring proper access to justice by appeal in the limited number of extradition cases where this would otherwise be denied. There would not be a reasonable relationship of proportionality between the means employed and the aim sought to be achieved. So again, the court is addressing the very point. The question is, are you personally at fault for the failure to file the documents in time, or is it the fault of your lawyer? And they're saying the surrogacy principle does not apply in those circumstances. We've also put before you the later case of O'Connor, where I won't go into it, where the surrogacy principle is again said to not be applicable to all circumstances, and certainly not applicable in these types of circumstances.
Yes.
Thank you.
Yes. Thank you very much. We would reserve our decision in this matter, and we would let you know when the judgment is available.
As the court pleases.
Of course, the stay that was issued will continue in order until the delivery of our judgment.
As the court pleases.
Yes, Madam Registrar.
All rise. The President and the judges of the Caribbean Court of Justice. This court now stands adjourned until 1:15 p.m.